Do you have your will in place? Do you have your powers of attorney done? I know this conversation is anxiety provoking. Everyone goes through it. But I have to tell you, these are the two most important documents you need to get done, like stat. And to help you today, we're going to be talking with Michele Gordon, who has been a family lawyer for over 30 years. So she knows all the ins and outs of wills and powers of attorney. And she also has cautionary tales. What could happen if you don't have those documents in place? This is a conversation that you are going to be glued to. So get your pen and paper out. Make sure you're ready to take lots of notes and stay to the end because I've got a great little gift for you to help you get started. So enjoy this conversation and I'll see you at the end. So now, Michele, when it comes to estate and wills and power of attorneys and all that, it gets really confusing for people. And I know from my personal story, my personal experience trying to deal with my parents, uh, my father was like deathly afraid of writing his will. And he actually told me, I don't need to write a will. Your mother will get everything. And I was like, no, that's not how it works, Dad. And he literally was so afraid that if he wrote his will, he would die. That meant he would die. There's that connection, that emotional fear of, if you make those plans, you're going to die. Like, how do you deal with clients like that? Who like they come to you, but they're so afraid. And how do you manage those clients?
Well, I think unfortunately, what you're saying about your dad is basically how a lot of people feel about wills. Not necessarily that they're going to die if they do one, but it's the last thing that they look at and they say they need one. And it's very hard to get wills clients actually in to do wills. Even real estate clients and family law clients, I impress upon them the need for doing it. But I'd say it's probably one of the least expensive areas of law because a lot of people don't have complicated affairs, but it's like pulling teeth to get people in to do it because it's not immediate. If there's no immediate gain for doing it, and I think people, it's like doing taxes, right?
Yeah.
There's a long-term benefit, but they're not going to see the long-term benefit, so they only see the cost, even though it's not a great cost to do it. But I mean, everyone needs a will, everyone needs a power of attorney. I think this became a lot more clear to people during COVID.
Mm.
I had a lot of calls um, of people whose parents were in the hospital already or weren't able to do a power of attorney or passed away, which is, absolutely horrible. But I think people sort of had their eyes open to what could potentially happen if you don't have a will and a power of attorney.
Yes.
Yeah.
Yeah. So I just want to sort of go back a bit and tell you my story. When I realized we needed a will,
Mhm.
we were young. I started my family and married. My kids were coming along, and we didn't have a will. We just got our house. We had all these big parent responsibilities and adult responsibilities, but we never thought we would need a will until one of my ex-husband's friends from high school, who was, again, we were all in our late 20s, was going to visit his wife who just gave birth to to a set of twins, which would be their like second
Right.
and third child. And he had a massive heart attack and he died.
Oh no.
And there was no will,
Mhm.
there was nothing. And it was just horrifying for her. It was the most tragic situation. And it opened our eyes to the fact that we need to get ourselves organized, not for ourselves, but for our children. Like, who's going to take care of our children if we both pass away? Like the really serious questions you need to ask about who's going to be responsible if something happens to you.
I think that is very important, and a lot of people do it for that reason. They start a family and they try to determine who's going to be the guardian of the children, because again, the guardian, even if you put it in the will, has to apply to the court to be appointed as the guardian, right, of custody or property. But at least it gives your instructions if you pass away as to who that person might be. So if there's competing factors or both sides of the family are fighting, it gives a judge as an indicator of what you might have wanted, or if something happens, God forbid, to you or your husband at the same time, what both of you would have wanted, right? So that's one reason to do a will. Another thing is people don't really draw a distinction between wills and powers of attorney, right?
Mm.
So powers of attorney you use if someone's incapable. In Ontario, you have two powers of attorney. One's for health decisions and one's for personal property. Powers of attorney, again, are probably the least expensive legal document you can get, which gives you the absolute most protection. And anyone that has a house or property or even a bank account should have a power of attorney. Because let's say in the case of a husband and wife, the one party becomes incapable. It doesn't necessarily mean to they don't have to die, but they become incapable. The other person can't refinance the house. They can't sell the house. They can't do anything with the property. If one person is the breadwinner and has a sole account, they can't access that account. So everything comes to a standstill, at which point they would have to apply to be the attorney for property, even though they were a wife or a spouse. And there's costs involved in all that, right? So, and other people could also step up. So really, for powers of attorney, they're immeasurable peace of mind. Like whether you're joint owners on a property or if you're a sole owner, again, if anything happened and you became incapable, who would be able to manage that property, sell it, refinance it, do what you needed to do. So a lot of people just don't think of that. And there's a lot of single parents that are, footing the bill and their kids are living there. What happens if all of a sudden something happens and the children have no access to accounts? It really puts your finances at a standstill and creates a lot of problems for the people that remain.
So if they had a power of attorney giving them access to property and
Yeah.
stuff like that, that would help financially?
But what it does is I set them up that because when you do just a normal power of attorney, if there's no conditions and restrictions, then it's like cloning yourself. So the person, if you had $100,000 in the bank, if you gave that document to the bank, they'd let it it could be transferred to you. So we don't want misuse of that. So I
Right.
usually include that a condition is that you have to be deemed mentally incapable by a doctor before it's used. So no one can manipulate your assets or do anything like that, right?
Right.
Although they still can be misused, and then you'd have to take that person to court, but that's basically fraud and outside the realm of what we're talking about today.
Yeah.
Literally, it would allow, if let's say your husband became incapable and that was the bulk of your money, you could take that power of attorney and a doctor's letter into the bank and they let you access that money to pay your bills. So then you'd be able to keep the house running, provide, you know what I mean, groceries for the kids, and have your living expenses covered in that case. And even in two family homes, I mean, it takes two incomes to run a household now. So, I'm looking at the old time version where there's one breadwinner, but I mean, in most
Yeah.
cases, not everyone has joint bank accounts, right? So you have a bunch of money sitting in one, and you might have long-term disability going into the account of the person that's incapable, but you can't access it. So a power of attorney would allow you to do that and keep going. And then
So the important thing is if you have a will, you should also have power of attorney.
100%. Lawyers always do it as a package, right?
Yeah. Yeah.
We follow instructions, but I think the power of attorney is just as important, if not more important than the will, because like you were saying, in a lot of cases, if everything's joint, like your dad said, right? If everything's joint and he predeceases, then yes, things might transfer to your mom. And then obviously she'd need a will, but you never know the order that they're going to pass away. So they both need a will. But
Yeah.
but if someone, you know, just passes away, usually it goes to the spouse, right? Or not necessarily the spouse if they don't have a will, there's intestacy rules, but anything joint would go to whoever they jointly own it with, right? But
Right.
power of attorney, if you don't have a power of attorney and the person's incapable, everything comes to a halt,
Yeah.
right? Nothing can be transferred. Usually, you know, if someone passes away, they might have life insurance, so someone has immediate funds, or, you know what I mean? There's different things you can do to
Right.
negate the situation. But if someone becomes incapable, it's really a total stop.
Yeah. And we don't know. We have to anticipate these things. That's why these documents are so important.
Mhm.
Correct?
Oh,
Yeah.
yeah, because you never know what's gonna happen.
Yeah. So
Yeah.
let's go back to wills.
Mhm.
Besides that story with my dad who was just so deathly afraid, let's talk about the actually what goes in a will. And because that too is seen as such an overwhelming thing. I know I have quite a
Mhm.
few friends who haven't done wills, ones that are married, ones that aren't married, single, and they're still like, they're, they're handed even a
Mhm.
questionnaire from their lawyer, and they just can't seem to get their head around
Yeah.
certain questions. So can you just tell me briefly, what are some of the essential areas within the will that you need to make decisions on?
Well, I'd say the two biggest essential areas are the estate trustees, and those are the people that, if you pass away, are going to deal with the lawyer and settle the estate and stuff. In a lot of cases, and with married spouses, they leave each other because obviously they know their financial circumstances, and then maybe, you know, a child or two children or something like that, or they might leave a sibling, if you know what I mean, if they're married or single, etc. So the estate trustee is the first decision. They should live in the jurisdiction. So if you're doing it on
Mm.
Ontario, they should live in Ontario, because then you don't, the court can otherwise ask them to put up a bond or something like that in order to deal with the estate. So that gets it,
But
right?
wow.
Yeah. So that's the first thing. The second thing is beneficiaries, right? And beneficiaries are who is actually going to take and when you pass away and how much they're going to take, right?
Yeah.
So when you're looking at that, again, there's a lot of different things. When you're looking at single people, I mean, they do or don't have kids, then you might be looking at siblings or friends or charities. In married couples, you have two parents, like you have the single family, which in most cases, you know, goes from one spouse to the other spouse to the kids, something like that. And then you would have someone that the estate trustee would hold the money in trust for the kids until they were old enough to take the
But you
money.
have to set up that trustee scenario.
Yeah, but it's still the estate trustee. So when you're thinking of the
Right.
trustee, it would be the person that's going to manage that money for the kids until they were, you know, 18 or 22 or 25 or whatever you
Right.
know. So those are really the fundamental things. Then the other thing that people have to understand is what actually goes in a will, because a lot of people think that everything they have goes into a will and forms part of their estate. And
Right.
that's not so, right? So anything that has a beneficiary designation doesn't go into your estate. It sort of
Yeah.
passes outside your estate.
Yeah.
So sometimes, you know, if someone has life insurance, it will go outside because there's a beneficiary designation. If they
Right.
own the house jointly, that won't form part of their estate. So sometimes they're left with their personal property, their bank accounts, you know, things like that that don't have a beneficiary designation, but you still need a will to be probated in order to access the funds at the bank.
Right. Yeah, which is so important. So now when it comes to the executor and trustee, those can be two different people or one person.
Well, it's basically an executor or a state trustee.
It's the same thing. And now I know from doing mine several times, is it important to have several options of trustees in case one trustee passes away or something
Yeah,
happens or
you always should have an alternative, because
right.
basically wills can sometimes last you throughout your lifetime. Like I'm just smiling when you said you've done it several times, right? Which is great. You know what I mean? You usually can't get someone to the table once, right? But I think once,
My life situation has changed. I divorced.
right?
So I think that when your life situation changes, you really need to, like anything, reassess your will, correct?
Yeah, that's 100% true. And I love that you say that because it just shows how on the ball you are, right? Because people don't like, I mean, they get divorced and they leave, their, yeah, I don't like their ex-spouse on their life insurance. They do all kinds of things because they don't follow through. So it's great to see that you followed through because it is a living document. So it changes over time. So in
Is,
your case, and people that have changed circumstances, that's exactly what you should be doing, right? So that's perfect.
so is it important to maybe look at your will every so many years just to like as a double check to see if it's still applicable? Like, is there a recommended timeline where you should be reviewing things?
I think basically it's what you said when there's changes in circumstances, like it could be life changes or it could be life changes of someone else because you could have an executor that passes away, right?
Right,
So then you'd want to look at your executors and say, okay, well, now I don't have an alternative, let's say, right? So who would I want to put in that place in case something happens to the remaining executor, right?
right.
And then there's circumstances with children, or like you said, there's divorces where some people include stepchildren and then want to take them out or different things like that, right?
Yeah, that makes total sense. And
Yeah.
so it's always, just to reiterate again, it's really
Mhm.
important when you do your will, you should always have a power of attorney.
Yes.
And like you mentioned, in Ontario, we have two different power of attorneys, one for property and one for health.
Right.
Is that common throughout Canada? Do you know?
Uh, they call it different things in certain provinces. They call it directives and certain, but it, basically there usually is two, but it goes by different names and it gives different sort of responsibilities to the person, right? The
Right,
property is more uniform throughout the country, but with a little bit of difference, right? But the health has a little bit more, movement towards it. And
right. And in the US, of course, it probably changes from state to state. And you would
probably.
probably have to go when you're talking to your lawyer and just ask them specifically, and they would hopefully advise you,
Oh,
right?
yeah, any estate's lawyer or person that does wills, they would have something comparable for sure,
Yeah.
right? To deal with these things, right? The other thing that I do want to say is though, power of attorney for health is different than a do not resuscitate, because I get that question a lot.
Oh, that's great to bring that up. Thank you.
Because people say, well, if I do my power of attorney for health, does that mean they're not going to resuscitate me? And one really has nothing to do with the other. So basically, the health is doing health decisions. So it would be if you're incapable, are they moving you out of are they moving you out of the house? Are they moving you into a new residence? Are they putting you in healthcare? If you're incapable, what type of operations you need? But it's
Mhm.
totally different than if the paramedics show up and they could do something for you to save your life and then, don't take any extraordinary steps. So again, it's very different. The other thing I'll just say is in a health director or power of attorney for health, you can say what you want as far as like when we say like pulling the plug, right? So you can say in your instructions that you don't want to be kept alive by artificial means, which again helps the people that you're leaving behind if they have to make that decision,
Yeah.
rather than having one say, this is what she said this day, or this is what, you know what I mean, and having conflicting things. I think it really helps the people that are left behind.
Yes, definitely. So now you can put that directive in the power of attorney, or is that a separate document?
But you can put it in your power of attorney for health.
Right. Yes, which I absolutely did. I remember. Pull the plug, please,
Yeah, I
immediately.
know exactly. You know what I mean? So that's good. Yeah,
Go
and then
ahead.
you can also put specific instructions if you want to be cremated, if different things like that. And you can there's a lot of things you can do in a will, but the basics are the beneficiary making sure your estate goes to somewhere and the executor in order to make sure there's someone to deal with your estate.
Yes, exactly. Thank you for that. And yeah, that reminds me, I should probably change my power of attorney because I wanted to be cremated. And now after I had this really great discussion with Susan Greer with the Natural Burial Association, I think I might be doing that instead. But
But
anyways,
just to say though, that would go in your will because your
right.
power of
Okay.
attorney stops acting once you die. And that's really a common
Right.
misconception too, right? That people are like, I
Right.
have my will, so my estate trustee can make all the decisions when I'm incapable, right? But they can't.
Mm.
It's the two separate documents that work in concert, right? So yeah, so if you have your burial instructions, that would be put back in your will. So yeah,
Thank you for clarifying that. Yes. And
yeah,
I had to remember that because both my parents just passed away over the past 3 years over COVID. And um, yeah, my sister and I were both power of attorney for both my parents, and then I was the executor. And
right.
there's a lot of overlapping happening in
Hmm.
decision making, and I had to remind my sister, you don't have to deal with this anymore, even though we were working in concert.
Right.
It was very stressful for her. So I'm like, you don't really have to do these things. I can take the full brunt of it. So
That's
don't worry.
that's hard. It's very hard. It is hard to be an executor, which brings
Yeah.
up another point is when you're appointing people, you also have to look at their ability to deal with finances, their ability to deal with emotions, right? So, sometimes when you're choosing between children or friends, those are really big concerns. And, some spouses don't leave the other partner because they'd say there's no way that they could function if I passed away. So it just makes
Exactly.
sense to leave them as an executor. So there's a lot of emotional stuff that goes into wills and powers of attorney that you have to think about too, you know?
Thank you for bringing that up. You're absolutely right. It's very important to pick somebody who can actually, put their emotions in a box for a while
Right.
in order to really get into all the paperwork and there's so much to do. It's not easy to die. It's not
No.
easy to settle estates, even if the estates are the simplest and you think they are,
Mhm.
it's not. That's why having a will and writing out instructions and giving directives to people to take over makes it a hell of a lot easier.
It is a process. And even with powers of attorney, when you're talking about the emotion, like you have some people that might have been brought up in a religious background, and then they're choosing to leave a sister that may be Catholic, but they're saying, don't keep me alive by artificial means. Like that's just sort of setting up an emotional turmoil, you know what I mean? And already an emotional time. So there's
Yeah.
things that you have to consider. Another thing that you really have to consider is whether you have a will or not, but it's always better to have a will and power of attorney, is to have all your financial documents in one place. Because even, when you have to go, if someone doesn't have a will and has to go through letters of administration, or even when someone does have a will, if the executor comes in, like you might not know where all the important papers of your parents are or who they bank with, or they might have investments you don't know about. And then you're stuck waiting for the quarterly statements or the yearly statements and redoing the probate and redoing the numbers. So, like, yeah, it's something that you should also keep in mind just to keep yourself organized with those type of documents.
Yes, that's a very good point.
Mhm.
So let's talk about nightmares. What happens if you don't have a will?
Well, if you don't have a will, then there are intestacy rules, right? That you go through. So certain portions go to your spouse and then your kids. But again, becomes very complicated. Like if you have a common law partner, but your spouse was, X number of years ago, then depending on the year, the rules change. They may be entitled, they may not be entitled. People can bring dependent relief claim if you don't leave money to them. It can just get a lot more complicated, and you also have to go through like a court process that's a little bit more complicated also. So
Wow. So
one
I
thing,
just,
assuming you don't have all joint assets, I go back to, right?
right. Yeah, exactly. Like if you're say a single person and you've got a lot of money, you've got siblings, you have maybe children from you know, like
Right.
post-divorce or whatever. so let's say it's me, if I passed and I didn't have a will,
Mhm.
what would immediately happen?
A certain amount would be divided between your spouse and your kids. So they would get
But
half.
what if I had an ex and the spouse isn't in it anymore? Like, what if I'm now
Well, if you
single?
had an ex, well, then it would depend on whether you were still married, whether you had a separation agreement, whether your separation agreement had a clause where you're releasing each other's estates. So it's very particular to the situation. Then you have to
Mm,
do a deep dive into what other documents were there, and if things are owned jointly with someone, or who's entitled to money that way, right?
right. So
So
what hap, so what does the bank just freeze all the funds?
yes.
Right.
Yeah, that's the downside of the whole thing, right? That everything is at a standstill until you can figure out what happens, right?
So it becomes a real mess.
Yes.
Yeah.
Basically it does. It becomes a real mess. The only access, someone would have to money would be if it was in a joint account. If you had joint accounts with your kids, if you had life insurance where they would be the beneficiaries, or any other investments that they would be beneficiaries of, right?
Yeah.
Everything.
Yeah. Yeah. It becomes a nightmare. I know this.
Yeah, yeah, no, it does, and the banks are pretty particular on wanting the certificate of appointment of a state trustee, so,
Yeah.
or a court appointment, right? They're not just going to start divvy out funds in case someone else exists that's entitled to them.
Yeah.
Mhm.
Yeah. I'm gonna have a really deep dive conversation with my financial advisor around all the financial stuff that you need to do, like
Right?
to make sure you're covered.
Mhm.
But from the legal point of view, is there anything else besides the will and power of attorney that people should be aware of when it comes to, say, property ownership or title on property, or, you know,
Well,
like I know that you have various hats that you wear. So like business stuff. Like what if you have a thriving business and you pass away and you have a partner? Like, what else do you need to like prepare?
okay, so in that realm, I would probably refer out because I don't do business law.
Right.
So a lot of people that have businesses they either have, if they're shareholders, they're with someone else, there might be a shareholder agreement, they might have, life insurance on the business, they might have all kinds of things, right? So they might have domestic contracts that phase out the business. So one, the wife isn't involved, but usually if they have a lot of money or in it and in business and stuff like that, they do have other documents put in place that would protect them,
I would think
yeah.
so. Yeah.
Yeah. So, I mean, sometimes with a sole proprietor, you could do it that, you know what I mean? That if it's a sole proprietorship, you leave the business to a child or a spouse or something like that. But usually when you're getting into a corporation and things like that, I would refer them out to a corporate lawyer because
Right.
there's other stuff that I don't do, right? That that they should be cognizant of. Another thing too is people put things in family trusts for tax purposes and things like that. I don't do those. So again, I would refer them out to people that did. So with respect to my practice, I'm doing mostly the basic family, right? Or, like step parents with their families and, things like that. So I do those types of wills and estates mostly. When they get complicated and go for trusts, then I would refer them out. With respect to adding people on, property in joint names, if you're thinking of adding a child, I would refer someone out for tax advice on that, because to see how it's going to affect their taxes and the capital gains,
Right.
who's going to pay that at the end and how it should be dealt with in the will. The only thing that you do have to remember is if you put a child on property, right, jointly with you, that they have control of that property, right? So if you
Yeah.
decide that you want to sell, or vice versa, if they decide that they want to sell, um, then you're setting up a dynamic where you might be forced out of your own home, right? If they bring an application to
That's a
sell.
good point. That's a
So
good point. So you have to
I'm
look
not
at,
hugely in favor of that.
yeah,
You know,
that's
it's
a really good point.
Yeah, it's something to keep in mind, right? So, but again, they look at the tax implications and whether there's a mortgage on the property and how best to do it that way also.
Yeah, yeah.
Mm.
Okay, so back to the will. So
Yeah.
executor and trustee, and then naming who gets what.
Right?
And if there's kids involved, there's
Guardian for your kids.
guardianship for the kids who,
Yeah.
and then layers of that too, because what if the guardian
Right.
first tier passes away, who then comes after that?
Right.
And then I guess like items, like if you had
If you
like,
have personal items that you
yeah,
want to give to someone, right, you can either put it in the will. If you put it in the will, then your executor has to give that item to that person. A
yeah,
lot of the time we say just leave a list, and it's instructive to the executor, but they don't have to follow it. So it depends on the worth of the item, right? I've heard stories where, clients have told me that their mom hasn't left they had a list, but they go put stickies on things so they know if their mom's mad at them, because if something had the sticky with their name last week and it doesn't this week, they know they're not getting that, right? So, but that's instructive to the executor. But then there's other people that might have, like an antique car that they want their grandson to have, and different things like that. And those would be worth putting in the will, because chances are you're not going to change your mind, right? And that's
yeah,
what it comes down to. It's a cost benefit analysis. It's like, if I'm putting it in the will, if I change my mind, I know there's gonna be a cost to take it out, right?
yeah,
So that's the one thing. So a lot of people just leave a list that's instructive,
yeah,
right?
that's great.
Then there's other things that we do include, like, because if you don't give the trustee powers, like to sell property and to have bank accounts and to deal with corporate shares, all that kind of stuff, then everything has to be wound up right away. So usually there's a whole host of powers that we include that would let them, potentially hold on to property if it was a bad market, right? And a lot of the times you might have two or three, siblings that don't need the property right away, that say, listen, we're all beneficiaries, but let's hang on here. So we usually give them some flexibility in that. The other thing too is when you're gifting money to a child that's a beneficiary, right? So if the child's a beneficiary, I always use a clause that says that basically the estate trustee can encroach on that money. Because let's say, for the benefit of the child, so let's say, you have two kids, there's $200,000, they get $100,000 each, and it's in trust until they're 21, like something simple like that. But
Mm,
say one of the children becomes ill, so the money's in trust, the executor can't touch it. But if you were alive, you would obviously have used that money to help your child medically. So I always put in a clause that the executor is able to access those funds. It might be from, we don't have to specify, but at least if you're putting someone you trust as the executor to make decisions on your behalf, you're assuming they're going to take the best care of your kids financially, right? So
yes, we hope so.
yeah, I always include that clause, right? Well, no, exactly. You hope so. I always include that clause because how horrible is it, that children
Mm,
can't get it. And it, not just medical education, the cost of education now, chances are you'd use that money to support your child through their education. So it gives them more flexibility anyway. So that can be built into a will. Um, let's see what else. There's also a Family Law Act clause, which is a little bit more complicated, but when you divorce someone, the amount that you inherit, as long as you put it in a sole account, it's a deduction. So it's deducted from your assets on the date of separation. Well, if you get $100,000, let's say, and you put it in a sole account, and you're together with your spouse 10 years and it's now 200,000, if you have this little Family Law Act clause in your will, then you can deduct the whole 200,000. Whereas if this clause wasn't in your will, you'd only be able to deduct the original one. So that's why
ah,
you have the Family Law Act. Obviously, if you put it in joint funds, you lose the deduction anyway. But there's certain things lawyers throw in just as a matter of course, you know what I mean? to help out their clients, obviously, that you don't even think about, but they're in your will.
Yeah, that's great. So now, okay, so that's all amazing. So we've got our will, we've picked our executor, we've made all of our choices with beneficiaries. We've signed our power of attorneys and designated somebody for each of property and health. We've stipulated how we want to die, but of course that can change. And that's all good. So what happens? Does it get officially registered somewhere? Is it just a document that the lawyer holds on to and then you hold on to? And if you want to give copies to your kids, you can, right?
So
Something like that?
generally speaking, a lot of lawyers hold on to the original because the only copy that you can use is the original, right? So a lot of lawyers are building up basically probate practices also. So usually that person would come back, to get the copy of the will, and chances are they'd use that lawyer, right? In my case, I don't hold on to original wills. I give them to the people, right? So I don't have them in a safety deposit box or anything like that. They have the original. I have a scanned copy that's worth really nothing other than I can recreate it and they can sign it if they lose it. So some people, you can register it at the court. Like there's a possibility of doing that through a registry. A lot of people just put it in a drawer with their personal property, or they might have a safe at home with, all their papers. You People think that you can put it in a safety deposit box. Not such a good idea, because unless the executor is named on the safety deposit box itself, if they go in with a copy, the bank won't open it. You need the original. So it's like this catch-22. You know what I mean? I've
Right.
heard a lot of lawyers say put it in a bag in the freezer. I don't know, because then it won't destroy in a fire. I've never given that advice, but I've heard it a lot from clients that come to do a will, right? And they said, oh yeah, my last will's been in the freezer for years. I'm like, oh, okay. But nowadays, I mean, God forbid someone had a fire or something like that. Like we have it on our computers. It doesn't take that long to redo it and re-sign it and re-witness it. You know what I mean? So
Yeah, but let's again look at the worst case scenario. Say, you live in California, your house just got burnt down, all the computer stuff got burnt down, your backup system got burnt down, you didn't upload it to the cloud.
right.
You let's say that the person has passed and they didn't give copies to their executor or their children.
Right.
How do the kids or family members find out if there was a will, if it wasn't registered, or if they didn't know who the lawyer was? How do they go about figuring it out?
They're not going to find it. They're not going to
Mm,
find it. And then they have to go the long route. And that
right.
actually happened to me when my dad passed away,
Mm,
as a friend of the family knew he did the will. And we looked everywhere for the will, but again, there's only the one copy, right? And I didn't find it until like a long time ago when I was packing up the house. My mom had predeceased, and it was in the guest book for her funeral, but who would have known, right? So I had to go the long route to get appointed as a state trustee, right, in order to do it. So you've got to tell people where it is, obviously, right? And they have to be able to have access to get in to get it, right?
yeah.
So that becomes the issue, right?
Yeah. So that's why it's so important for you to do a will and then maybe get original, because you can get three original copies.
You can get copies, but they're not really original copies. You can only use the original, right? So
Okay.
it's not an original copy or a notarized copy or whatever. You have to have that original will. That original will has to be filed with the court on probate,
Right.
right?
Yep.
Mhm.
So that's why it's so important to, let your children know where it is and all the situation, whoever the executor is, you need to communicate that,
You need
right?
to communicate it, and you need to have all the documents that they're gonna need. The other thing that I do when I do my wills is I do what's called the affidavit of execution. So when someone is watching, there's gotta be two people present that aren't beneficiaries that watch the person sign, right? When they're doing their will, and watch them initial each page. So a lot of people don't do it at the time, but I give them, like my assistant and I watch the will signing, right? And then we do the affidavit saying we were present at the same time and we saw it, witnessed, etc. So they have that first document. So the executor can take that package to the lawyer when someone is deceased, and they don't have to chase around and try to find the witnesses at that point,
Right,
because knows where we'll be at that point, right? So at least they've got that first document that they would need for the probate.
right.
So I give
So,
them as that package, basically.
yeah, yeah, that's great. And so how young do you have to be to make a will?
Age of majority.
It has to be age of majority.
Yeah. So yeah. Yep.
So someone who's like what, 18? Are we
Yep.
age of majority 18 here, right?
Yep. So
18, 21, whatever it is. Like
yeah.
someone that age isn't going to be thinking, I need to write my will. I need to do a will.
No, probably not. No, probably not. You know what I mean? Like, in all honesty, right? They're not,
Yeah.
unless, they have their own substantial funds, right? And then they're usually directed by, maybe a parent, etc., that might have their own substantial funds that's been through it, right? But I don't see younger people coming at all, really.
Right. Yeah. But then in all seriousness, when should you have a will? Like what does the life situation have to be for you to really seriously start writing a will now?
Well, I think you have to have some assets, right? Like I'd say, people that are living at home and going to college and not making any money, you know what I mean? They probably don't need a will, right? But I'm just trying to think of an example. An example that we had, which was unfortunate, was after I finished my BCom. A friend of ours got, well, a lot of the people from the BCom program got jobs, right? So they had pretty significant incomes down in downtown Toronto, and she had a place down at Harborfront, right? But her mom lived up north. I can't remember what town it was now, right? But she ran out to get pizza on a rainy night and got hit by a car, and she
Oh,
unfortunately was in a coma for months. Which she didn't have power of attorney. So she would have been what, 23, 24, right? But had fairly substantial income at her job to have like a condo down there, right? And she didn't have a power of attorney, didn't have a will. So her mom ended up paying, the expenses on the condo for months, because of course you hope that your daughter is going to get better in return. She subsequently passed away, unfortunately.
mm,
Again, it basically bankrupted her mom.
ah,
So I would say, when you're young, you have financial obligations, you're earning money, that's probably a good time to look at, doing your first will. And then it might change a couple of times if you get married, if you have kids, et cetera, right? It'll
yeah,
change during your life circumstances, but it's something to think about it, because it was very unfortunate, because, her mom didn't
I
have the
can't
same
imagine.
resources that she did to maintain the condo, but she did. And, it was devastating, right? So it can totally financially ruin other people, right?
Yeah. What about a power of attorney? Even if you're not making income and you're still like in your early 20s, you're still kind of living at home, whatever. Should you still maybe get a power of attorney document? Or
Like,
is it just assumed that if something happens to you, your parents are the ones to make the decision? Like, will anybody challenge that?
well, some people might, like, and again, you don't know, because, there's so many divorced families and stuff like that, right? That, like, they fight when people are, alive, let alone when they're in bad circumstances, right? And then
Mm,
if the person has money, people are going to fight even more, right? So you can get into litigation about who's looking after who and who's doing what, etc., right? you know
right.
it's always better, I would say, just to do it, just to have it, right? Because you never know when anything's going to happen to you, right?
Yeah. Yeah.
I mean, emergency decisions, I mean, they usually, for health for sure, would go to, the spouse or the parents, or the doctors would go to sort of the next of kin, right? But the problem is when people are fighting it, then where do you go?
Yeah, then it gets really ugly and just complicates everything.
It
So,
can.
so the advice is get your will done as
Hmm.
soon as you can, as soon as you're making money, if you own a car,
Yeah.
a condo, whatever it is, even it doesn't matter, like any time from age of
Especially if
majority
you own
onward.
property, especially if you own property 100%. You know what I mean?
Yeah, yeah,
Yeah.
so important.
Yeah. Yeah.
And so now, do you have a sort of questionnaire outline that you give your clients before they prepare a will? Do you have that?
I don't usually actually because I usually just talk to them and go through all the assets and the debts they have because I feel like I did try to do the questionnaire thing and then a lot of the time I never heard back from the client, right? So I think as it is like you were saying, people just are reticent to do it anyway. And then you send them a big questionnaire and then they've got to figure out if they own something jointly or singly. And when they don't have the background of it, then they're not sure why they're giving all this information. And I feel like it's a little bit of a vacuum. So I do spend a fair amount of time talking to my clients and getting an idea of where they're at and who the players are involved and what their family dynamics are and things like that, before we go forward and what forms part of their estate, what doesn't form part of their estate, and what obligations they have to other people, might be spousal or child support and different things. So I try to go through all that with a client, but I find a lot of them, if they haven't done it before, might even be confused about what a will is versus a power of attorney. So just sending them a form, I didn't find that it worked that well.
Yeah, that's actually a really good point. Like for me, because I've done it before, sending me a form to update was easy.
Mhm.
But the first time I do remember walking in and making an appointment with my first lawyer. And it really it sort of helped me hash out some things so that I didn't think about things, like to hear someone say, okay, so if that person passes, who would be the next person in line? Like having
Right.
a conversation at the beginning is, I think, really a good point. It's
And
really
yeah,
essential.
and it's interesting because people don't think about it. And even when you have, a husband and wife that have kids and grandkids, right? Like I've had certain ones where, it goes from husband to wife and vice versa, and then divided equally between the kids. And then you say, well, what happens if a child predeceases, one of your children predeceases?
Mm.
And you can have a wife that says, well, their share goes to grandkids if they have any. And you can have a husband. I did one the other day. The husband's like, no, it's going to divide it between the surviving children, and that's it. Right. So you have an actual couple that the first layer is the same, but the second layer, it depends on who dies first, right? Because you know what I mean? If the wife dies first, the husband gets it and then he can do whatever he wants with it, right? So it's just going to surviving children, right? So it's very interesting, the dynamics. And when you talk through it with people, you find sometimes they have totally differing dynamics, right? And then you have people that are married, like you have to leave 50% obviously to your spouse because of family law. But some people come in and say, like, I don't know, I had a friend and they passed away and the husband got all the money and then he found someone else and now the new wife's got all the money and the kids have nothing because they're adults, right? And that can happen. And some people are like, I don't want that to happen at all. So
Yeah,
there's a whole
that's a
bunch of things to talk about, right?
that's a really good point. And yeah, you can't if you haven't done it before and you don't even know what the scenarios could be. It's
Mhm.
so important to have that conversation with your lawyer.
It's true. And with each other. Like I feel like, you know,
Yeah.
sometimes,
Sometimes having the lawyer as a mediator is a good thing.
yeah, but I mean, sometimes it gives them a lot to think about, like I don't feel like I get the instructions right away, like you're saying. I might, we might discuss, what's forming part of their estate, what goes automatically. Then we might discuss who the beneficiaries are. Then they might have a few ideas about executors and beneficiaries. Sometimes even easy wills are a process.
I
So
agree.
yeah.
I
It takes
agree.
time. It takes
I
time. You
Yeah.
know?
I agree. And
Yeah.
I think it's really important to handhold. That's why going to a lawyer is so important. Unless you are very clear on what you want and you write your own will, like is that still legal? Can you write your own will and get someone to witness it? And is
It's
that a
got,
legal document
yeah,
or?
it's gotta be all in your own, it doesn't need to be witnessed. It's gotta be all in your own handwriting and signed in your own handwriting. And it's a holiday.
Ah,
Yeah, yeah.
okay, that's
Then it's a
great.
matter of whether you catch everything, right? Like I'm sure the Family Law Act clause won't be in it. I'm sure there, you know what I mean? I'm sure
Yeah,
it won't be captured if you did it, but I mean, there's the possibility of doing that.
yeah, yeah. Okay, well, that's good to know. Just for people who are so reluctant, it might be like their first attempt. And
Mhm.
then later on, they might get comfortable since they've already made the attempt to actually go to a lawyer and do it all with all the legalities in it.
Mhm.
So that would be a good thing. As long as they do a will, my God,
Yeah,
just
yeah,
do the will. Please,
yeah.
people, do your wills
And powers of attorney.
and powers of attorney, please.
Yes, 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 for sure, for sure. I'm
It
glad
was
to hear you're protected.
Yes, well, listen, I'm a responsible person
Yeah,
and I don't have any fear of death, so I'm a bit of an anomaly. I know there's a lot of fear around death, but I had to work with my father
right.
for years. He refused, 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 and then finally, and it's self-fulfilling prophecy because he kept saying, "No, I don't want to do it. Well, like this fear of death thing," and of course by the time he finally submitted, a
Hmm.
year later, he died.
Oh, that's unfortunate. Yeah,
Yeah, but I'm like grateful that he, agreed and
right,
I
right.
could find the lawyer that would work with them, was patient
Hmm.
um they did have an argument about some money,
Right,
like because they didn't talk like, they weren't good communicators, they're
right.
at a late 80s, they're just like, I'm gonna do my own thing, you're gonna do your own thing.
Mhm.
But it was a good process. I was so super stressful, but it was, I'm grateful that we finally did it because then it made the rest of the process easy for me because I had the brunt of the responsibility. But the stress of my dad thinking about it for so many years, it must have been awful because, he just that refusal to look at the situation, the
Right.
refusal to just make the decisions was he was hanging on to that for years, and that stress of, no, I'm going to die, because I wasn't the only one asking him to do his will. His financial advisors were asking him, my mom was asking
Yeah.
him.
Hmm.
So there was a lot of energy that caused so much stress for years
Hmm.
that didn't have to happen if he just did his will,
Right, right.
you
But
know.
you know what, people, yeah, it's difficult. You know what I mean? And if he's never been an executor or hasn't, you know what I mean, been in the position where he's been left to deal with something like that, with someone that doesn't have a will. I think a lot of people now have unfortunately been left in that position where people didn't have powers of attorney, where the people didn't have wills. So I think these horror stories are getting out at a greater level than they might have been before, right? So yeah.
Yes, yes, I hope so. And also, I think people need to realize that even if you have a will and everything's written out,
Mm.
you don't all of a sudden get a check. And like money just doesn't
No,
get
no, it's got to go through the probate process, and that's why you have to have an estate trustee to do that. Then they get the letter
exactly.
that goes through the process, right?
Yeah,
Right.
and part of that process, because I did it,
Mhm.
is paying all the bills,
Yeah,
paying the income tax, which
yeah,
sometimes is a year later. You have to wait to get everything settled. Like all of the
it's a process for sure. It's
like the whole, and that was a simple estate. My parents didn't
yeah.
have a lot.
No,
And
it's true.
I'm thinking, wow, this could, like, it does, it can take years,
Yeah,
and it could take double that if you don't have a will. Like, people have to understand that it's so important, the most important document, I think.
I
Um,
think so too. I think wills, but kind of think powers of attorney too, because I
Yeah.
think a lot transfers, like if you're not a single person, a lot can potentially transfer, right? If you pass away, but if you become incapable, everything's just sitting there, right? So yeah, and I'd have to say, I think I, from my client vantage point, right, of the clients I've had, I would say probably more of my clients have passed away that don't have a will that
Mm,
did have a will. Like there's very
wow.
few of my wills clients that have passed away. I'm just saying, but I know there's a number of my family law clients that just didn't, you know what I mean, wouldn't go that next step, right? And have subsequently passed away without a will, right? But I'm just saying, so to your dad's argument, or people that have your dad's argument, from my practice, they're not like dropping like flies once they have a will, you know?
Yeah. Unless you leave it to the very last minute,
Yeah. Oh, yeah.
and
Yeah.
then you will drop dead.
Yeah. Well,
Um,
yeah.
this has been a great conversation. And I just have one more question for you.
Sure.
When was the first time you made your will?
Oh, God. I probably made my first will, and I probably came late to it too, but I probably did it once I had kids.
Right.
Yeah. And I knew I should have done it earlier, but, I probably did it once I had kids, if I have to be honest.
And how often do you revisit your will or make adjustments or?
Um, Again, only, through like marriage or, or divorce is when I've done it, right? So, it's
Yeah.
changed, from partners to, or partner to children, right? Basically.
Yeah.
That's about it.
Okay.
So
That's
life,
great.
life changes, you know what I mean?
Yeah.
And at the same time, I did change executors. So, it was sort of went hand in hand. My life went in a different direction a bit. So, everything changed when I did the new will.
Yes. Yeah. Very important when your life changes and friends change and executors change and yeah,
Yeah.
children change, grandchildren are
Oh,
born.
100%. Well, yeah, not necessarily. Like some people can use the same will forever because they're just married and it's going to their kids and then, or their wife, their kids, and then their surviving grandkids. You know what I mean? So
Yeah.
some people can actually keep the same will forever. So it just depends on your life circumstances,
Yeah.
and
Yeah.
how complicated they are, really, right? But I would say probably my instigator was having kids.
Yeah.
Yeah.
So do your will,
Yep.
do your power of attorney, like stat right now. If you're in Ontario, I'm going to give you all of Michelle's contact information below so you can contact her, get it
Thank
done.
you.
And otherwise, contact your local family lawyer, anybody. I mean, there's standards to fees and stuff like that, obviously.
Mhm.
But just get it done. It is so worth it. It's creates such peace of mind. And it also takes the stress off of your immediate family as to what's going to happen when you die,
Mhm. It
right?
does, and I would also say too that things are a little bit more easy because you can also witness virtually now too, right?
I
So
love that.
yeah, so it gives a little bit more option for people that might be housebound or older, or but really need to do it. So it's really something that they're trying to make accessible to everyone now, right? Even
What
more.
about video wills? Is that a legal thing?
I don't believe so. No, you still got to
Okay.
be and everything. Like you can witness through the video, right? But you still have to originally sign. So there's a little bit more of a process to it, but it's still available to do.
Great. Thank you
Yeah.
so much for having this conversation with me today,
Oh, it was
Michelle.
great. Great. Thank you very much for having me.
Thank you so much for watching this video. Are you excited about doing your will and your power of attorney now? I hope so. But if you have more questions, please include them in the comment section below, and I will do my best to answer them or direct you to somebody who has the answers. So here's your little gift. To get started, I've got a little free download of all the things you need to answer to start the process of thinking about getting your will done. Once you've done that, look, it's about you doing it in your own time. No one's going to force you to do this, but it's a really good starter. So download it and then bring it to your lawyer when you're ready. And in the meantime, share, like, and subscribe to this YouTube channel for more informative videos on getting ready to plan your exit. Thanks for joining me, and I'll see you next time.